You can use ChatGPT even to do a lot of research. The program will tell you a lot of the steps that you need to take, but it doesn't help you with
Before we get started, I want to thank Trisha Copeland for introducing me to our next guest. Today on Time We Discuss, I want to welcome Laura Schneider, and it's time we discuss what it's like being a patent attorney. Laura, thank you for joining me today.
thank you for having me.
Oh, absolutely. So this is going to be cool. So Trisha was a patent agent. You are a patent attorney. They're loosely
Mhm.
related. So let's start there. Where does your job begin and a patent agent's job end? What are the differences?
So there's actually a lot of crossover. Both a patent agent and a patent attorney can prosecute patent applications before the USPTO. Where they diverge is that a patent attorney can also assist you in other aspects of intellectual property that are related to patents. So we talk about trademarks, copyright, trade secrets. So those are all of the things that a patent attorney would be involved in. And we also will manage your international portfolio. So we'll instruct, uh, you know, attorneys around the world related to your project.
So I want to hang on copyright for a second. I'm generally familiar with the copyright process, more so than the patent process. Now, I spoke to Brian last year. He was an inventor. So we talked a little bit about the patent process. But specifically with copyright, are there different copyright attorneys that handle copyright specifically, or is that also just you? Are they two different things? What is that like?
The funny thing about copyrights is one of those few things that you don't actually have to register or create, some sort of, certificate with an office ahead of time in order to have rights. Copyrights are created at the time of creation. Even this conversation, this podcast is already copyright protected, even without a registration. And the whole purpose of copyrights is just fairness. The whole point is for to prevent others from copying your creation. It protects the artist.
So if there's a copyright claim, would someone
Mhm.
go to a, could you handle that as well, or would I have to find a specific
Yes.
copyright attorney? How does that work?
I am a prosecutor in all of the actions that I take. So copyright, trademark, and patents, I'm a prosecutor, meaning I register those. There are different types of attorneys who will come in at different stages. So first is the prosecutor. That's going to be the person who creates or helps you, create the title to what you have. And then the next step might be an attorney who is a transactional attorney. That's going to be somebody who helps with, let's say, licensing agreements, business contracts, those types of things. And those attorneys, they deal with the property, but they're transferring title effectively. So that's a different attorney. And then the third type of attorney is going to be the litigator. They're the ones you see in the courtroom, who go in and get those $200 million settlements out of Samsung and all of that. So,
Interesting. I assumed that would just be one person or one type of
uh,
person, but they are distinct.
and it's intentional, at least on, the division between the prosecutor and the litigator is because you don't want to litigate your own patents because that can get into some issues with attorney-client privileges, because there might be some questions about what were you thinking when you wrote on page 48 of this patent, and that's problematic.
Okay, that makes sense.
Yeah.
Okay, so you talked about trademarks, you talked about copyrights, patents, trade secrets. Does a patent attorney typically deal with all of those, or is it no, you kind of start to like, you might specialize in patents and then slowly take on trademarks? What is that typically like if someone's looking for a patent attorney?
A lot of attorneys will focus solely on one aspect. I actually handle all four of those. And I like to say that the different aspects of intellectual property, they complement each other and they serve different purposes. So, for example, a patent is effectively a monopoly. It gives you a right to prevent others from making, using, or selling your invention. A trademark is it's actually protection for the consumer. And this goes all the way back to the bread baking days of England and, blacksmiths. They actually had to mark their bread or mark their silver with the shop logo so that the public would know, okay, if I buy this bread, I know, this is what I'm getting. So that's what we have today with trademarks, is that if somebody buys something branded Coca-Cola in the store, they know exactly what they're getting. Copyrights we talked about, that the intention of copyright is to protect, prevent actual copying, and the trade secrets are exactly like they sound. It's your secret, and so there are certain protocols to protect those secrets, because once they get out, they're out and you can't do anything about it.
All right, let's jump to how about a typical day? What is a typical day like for you as a patent attorney?
I'll talk about my favorite type of day. And my favorite type of day is when I get a call, first thing in the morning, and, say from a client who says, Laura, I've been thinking, and I'm like, oh, yeah, you've been thinking, that is great. And so, give it to me. And so typically a client's discussion is going to be about, first of all, a product idea that they've had, maybe some business marketing associated with it. We'll also talk about, in many industries, it's, competition is tough. And so there's going to be a conversation about what's the competition doing right now, and what will they do once they see your invention out in the public. And so we go through all of that, discussing our strategy of, first of all, is a patent appropriate? And if so, is it appropriate at this time? There's a narrow window when it's ideal to submit a patent application. You don't want to jump the gun, but if you wait too long, then you've also lost some rights. So finding the right time to apply is a big deal. And as part of that conversation, we also discussed how, any other related actions we need to take, regarding the marketing of the product, and go from there.
Okay, so let's hang on this for a second. Very generally speaking, when is it? You talked about if you wait too long, you're at a disadvantage, and if you act too quickly, you're at a disadvantage. What makes it like that perfect zone when you should be acting on it?
Yeah, and it's squishy to divine. So there is, there is no, black and white point. But let's say applying too early. A lot of people, they want to submit that patent application right away, the day they woke up with a thought. Well, the problem is that, you're entitled to a patent once you have something that is new, useful, and non-obvious, and has utility. And then as you go through that, whenever, if you submit the application too early, you have just a broad little idea, but you may not know all of the details of how to implement your idea. And it happens more often than you would think, that as your engineers on the team are, getting down to the nuts and bolts of the idea and actually implementing it, they encounter other problems that they have to solve. Well, those problems that they solve are themselves patentable. And if you've applied, you've lost that opportunity. And conversely, sometimes, and I did see this years ago, a company had submitted applications, multiple patent applications, far too early. Those applications were allowed and did issue into patents. The problem was they couldn't actually create the product. They couldn't build it. Well, 10 years later, they figured out how to build it. And they thought, okay, we'll submit an application on this product. Well, their own prior patents blocked them from getting patents on that, what they actually were able to create. So that's what can happen if you file too early.
Awesome. That's a really good example. I love that. Okay. So during our conversation before we started recording, you mentioned that you actually became a patent attorney later in life, which I love stories like this. So let's focus on that. Very briefly, what did you do before, and then how did you transition into this career?
It's actually very common what I did. A lot of, especially a lot of patent attorneys, start off their careers as engineers. I was a design engineer in mechanical engineering, with an undergrad in mechanical engineering. I didn't really enjoy it, to be honest. I just, it was good work. I was treated well by my employer, but I really just, I didn't enjoy spending a year thinking about whether the angle between two pieces should be 0.487 or 0.486. I didn't care, so that's when I started thinking about changing careers and came to this. So switching, it was tough. It was tough to switch gears later in life, and especially at the time, I was a single parent. I went to law school with toddlers in tow. I don't recommend it. I do not recommend law school if you are a single parent. You've got to have a lot of family support. That being said, once you're finished with law school, then career as a patent attorney can be suitable for single parents. It can work, and it's actually very rewarding. You can work your schedule around your family needs. But I will say making the switch is hard.
That is good to know. Okay. I love that story. I was speaking with Christopher Stockwell. He was a prosecutor, and his story was really cool. He dropped out of high school, kind of bounced around a little bit, ultimately went back, got his GED, I guess is what it was, and then went on to be a lawyer and went to law. And he talked about what it was like being in law school later in life. Really, really cool story. So it's nice to hear his perspective and hear your perspective as well. Similar and different. I absolutely love that. So you finish law school, you pass the bar. What did you do after that? Did you go to work? I'm assuming they have different firms. You started your own firm. What did you do immediately afterwards to get started as a patent attorney?
I initially went to a boutique, a small law firm near my law school in Boulder. And I spent about 4 years with that firm before opening my own practice.
Going back to family balance, okay, you talked about being in law school as a single parent. Recently, an episode just dropped with Russell Little. He was a divorce attorney, and for a period of his life, he was also a trial attorney. And he talked about when he was a trial attorney being in court and how it was very all-encompassing, that it makes life outside of work very, very challenging. So that leads me to this question for you as a patent attorney. What is the work-life balance like? I assume it's drastically different based on what you said about being a single parent post-law school. But generally speaking, what is the work-life balance like for you?
The work-life balance for a patent prosecutor or intellectual property prosecutor, all of this is actually very nice. It's very comfortable. Again, once you're finished with law school, every deadline that I receive is at least 3 months out. So I've got 3 months to prepare my work schedule and work around it. It's very rare that I have something come up that's going to be, the last minute, drop everything and work late into the day. And the only time that happens really is when I've got a client who, it's going to be somebody who's in conversations, potentially with licensing or something like that. And they need something on file quickly with the USPTO to establish priority dates and things like that before they have a meeting. So it's possible that somebody might say, we've got a meeting on Friday. Can you get this filed beforehand? We can do that. But, typically I've got 3 months notice.
Okay, that sounds pretty good. That sounds pretty good.
Yeah.
Okay, so talking about your engineering background, okay. When I spoke to Trisha, she talked about her background, I believe, was in microbiology, chemistry, I think. Absorbed a little bit of physics through her work as a patent agent. But she said, if she were doing anything engineering, for instance, that's outside of her realm. She wouldn't be able to do that. She'd have to pass that on to someone else, probably someone like you, actually. So being a patent attorney, I'm assuming you have those same limitations where it's like you're focusing probably on engineering, may have delved out a little bit. What's that like from your perspective?
Every patent attorney and also patent agent has to have an undergraduate degree in engineering or one of the life sciences and things like that. And typically we will specialize in our area. For example, my undergraduate degree is in mechanical engineering. So I take on work that is anything mechanical or electromechanical related, and also software patents. But I will not handle chemistry or biochemistry, and that's how Trish and I, we refer to each other. If I've got somebody who's looking for that type of application, then I'll refer them back to her.
How common is, and I don't know if you could answer this, but how common is it for a patent attorney to have their own firm, to just, they finish law school, they want to start their own firm, they want to work with inventors or working with, copyrights, trademarks, trade secrets, that sort of thing, intellectual property. How common is that, or how difficult would it be to get started and have to build up the clientele? Is there enough out there? What's your opinion on that?
I'm not exactly sure on statistics for that. I do know it takes about 5 years, 5 years to really establish your client base in order to be able to, open your own practice. And in any case, I would still recommend being with a law firm in the beginning, because there's, law school doesn't actually prepare you to be a lawyer. So you still need a few years to figure all of that out. Once you decide to make the jump and go solo, opening your own practice is a matter of filing a few documents with the state and, with the USPTO, and you're in business.
It's funny. Russell Little said the exact same thing, that law school doesn't prepare you to be a lawyer. So I don't know if you watched that one or if it's just the same sentiment, but that's.
No, it's exactly spot on. Yeah.
You said something that made me think of this. I don't know if you specifically talked about working nationally or not, but this is where my thought is going now. So the type of law that you practice, I know typically, lawyers, they practice within their state. If they want to work in a different state, they have to pass the bar for that specific state. How does that work for you as a lawyer of intellectual property? Can someone in a different state call you and you represent them as the patent attorney, or no, they have to be within the state, or wherever they're calling from, you have to be licensed in that state? How does that work for you?
I can and do represent clients from across the US or internationally, because I'm licensed to practice before the USPTO. That's national in nature. So the patents, copyrights, and trademark are all national in nature. Where it can, and I think some attorneys can get in trouble with this, is that, say they've got a client and they've represented them in prosecuting a patent application, but then that same client wants to open a business in another state. That is where that's where they get into trouble. So you have to secure local representation, or let's say if there is a conflict, which I'm not a litigator, so I don't do this anyway, but if there was a situation where there's litigation between multiple parties, the attorney has to be in that state.
Okay. If changing topics completely, if I have an invention and I want to get a patent for it, do I need a patent attorney or a patent agent? Can I do it myself? What resources are out there for the average person if they want to try to just do it on their own, maybe save a couple bucks?
That's a big conversation right now, is that, it's AI. You can use AI, you can do a lot of research, and it will get you, these days, you can use ChatGPT even to do a lot of research before submitting a patent application. They will tell you, and I've tested it out, the program will tell you a lot of the, the steps that you need to take. But it doesn't help you with the strategic decisions. And so I see the future of patent attorneys, intellectual property attorneys. We're going to move away from all of that nuts and bolts kind of stuff, the mechanics of submitting the application. And our conversations are going to focus more on the strategics of what you're going to do, because that's something that AI, they can't replace. They don't know, only what your competitor is really thinking, what they're going to do based on the last 20 years of what this competitor is doing, like where their mind is stuck. So attorneys need to be ready for that. Pretty soon people will be able to submit their own patent applications, and they'll be pretty decent. But we need to be involved with the strategic aspects.
Interesting. Okay. So hanging on AI for a second, how much are you able to leverage that in your current role? I think you said before you could see like other people using it in the future, but how about in your current role? Are you able to do much of anything with it, or it's not very helpful for you?
I do not use AI, in the space of, say, writing patent applications and things like that. I write all of my work from scratch. Where I use AI is as a research tool. So it's very helpful to me, which comes down to also helping clients because it's reducing my time and how much I'm billing for it. Whenever I'm researching, whether it's other, sometimes I research other companies or sometimes researching laws in other countries because, we're managing patents in every country. And so, I don't know what the law in Japan is for something, so I'll look that up.
So hang on that. How much time do you have to invest in how much time are you investing in researching? How difficult is that to, and it probably varies wildly, I assume. But generally speaking, how much time are you investing in that?
It's a lot. And especially, the more complex the invention is and or the more competition there is in the industry, there's going to be more research done for that. So it's all over the place. Sometimes we submit patent applications without even doing a prior search. Because if the client, so the point of doing, we'll say, a freedom to operate search before submitting a patent application is the point of doing that is to avoid a huge expenditure on manufacturing or, ordering all of your product. So you want to do a search before you spend $1 million on that. But if you're a small business and, you're not going to spend a lot on your, building or a manufacturing facility, I'll file applications without even doing any prior search and just let the USPTO do the search for us.
So when you finish law school and you pass the bar, are you set and ready to do what you need to do, or do you also have to get any kind of certification with the USPTO? I think was the acronym.
Yeah.
What is that like?
Well, it's a two-step process. I like to say patent attorneys are a special kind of crazy because not only do we have to pass the bar exam, we also have to pass the patent bar exam. So that's two of those there. Not fun. But once you pass both of those and obtain your registration, you can practice.
How often are both those offered? I know at one point in time the bar was, I don't know if it was like quarterly or every other month or something, but that's dependent on the state. Can you take them fairly, if you take it once and you don't pass, can you take it again pretty quickly, or they're spread out, which might make it difficult?
I'm not sure anymore on the patent bar exam because I actually was a patent agent before I went to law school. So I took the patent bar back in 2010. I haven't paid attention since to how often that's shared. I think the patent bar is available anytime or very frequently. And the bar exam is different in every state. In Colorado, it's twice a year.
One question I like to ask different people I'm talking to, there are different attributes of different jobs that could be deal breakers for certain people. And the example I like to use, if you don't like sitting in front of a computer for 8 hours a day, computer programming is probably not for you. So I want you to think about your job and different attributes and think about if someone doesn't like this one thing, then being a patent attorney, that is not for them.
Two things: being in front of a computer all day, that is a lot of it. But in addition to that is attention to detail. If you do not like paying attention to detail and you do not care about the long-term stress or chess strategy with the USPTO, then being a patent attorney is not for you, because you will be talking about a single word that you used one time on page 28 of an application, and you need to know why you chose that word.
Laura, this is really, really good information. I am running short on time, though. One thing I like to do whenever I'm speaking with someone is to give them the opportunity to talk about a project they're working on, a cause they believe in, about their business. So if there's something specific you'd like to talk about, the floor is yours.
As a small business owner, I am with rogue.law, ROGUE.law. I'd be happy to talk to anybody if they want to reach out and talk about if they have any questions about what it's like being a patent attorney, I'd be happy to do that.
That is awesome. Thank you for that. I will put that link in the show notes. It'll be on the website. It'll be in the description. It'll be all over the place. So when people are trying to find you, they can easily find you.
Thanks a lot.
Absolutely. Laura, it's been awesome having you on Time We Discuss and we learned what it's like to be a patent attorney.
Thanks for having me.